Did the Minnesota Supreme Court just create the strongest duty to retreat law that we have ever seen? That's what we're going to be talking about today. You're not going to want to miss this one because this is going to be insane. So let's get into it. So let's start with a quick summary about what happened. We go back to June 2nd of 2021, and Mr. Blevins, that's our good guy, that's the defendant, was basically on a train platform outside US Bank Stadium, and there was a woman and two men that were loitering there. Mr. Blevins is walking past the woman. She says something to him. We don't exactly know what it is. He spins, says something back. And then ultimately, there's a man, one of those two men that's with the woman, starts walking his way over to Mr. Blevins. Now, at this point, a train arrived. People start to step off the train. Now, the court, in their opinion, linked in the description box below, described what happened next. Quote, according to Blevins, the man in the sweatshirt told him to come into the platform shelter outside the view of the surveillance camera so that he could slice Blevins' throat. In response to the threat, Blevins pulled out a machete out of his waistband. Blevins then moved toward the woman and the man in the sweatshirt, yelling and holding the machete. The woman and the man in the sweatshirt began backing away from Blevins. As the man in the sweatshirt pulled his knife away, because by the way, he had a knife out, the man in the tank top aggressively walked up to Blevins. So basically, two of the bad guys retreats, one started aggressively walking up. And basically, the court goes on to summarize the fact that, look, this whole standoff lasts for about a minute. Blevins has his machete that he kind of steps towards them. He doesn't charge them, but kind of like, does like a false lunge or something like that. And he's waving it around a bit and all that kind of stuff to get them to go away. Because hopefully the last thing bad guys or anyone wants to do is mess with a guy who's concealed carrying a machete. I'd be curious to know what that backstory is, but for now, we press on. So the whole thing lasts for about a minute. The bad guys move away after they made, a death threat while holding a knife, saying that he's going to cut his throat. And now we have the police show up. And naturally, because this is Minnesota, Minnesota, oh my. He winds up being arrested, charged with second-degree assault, fear with a dangerous weapon, which, by the way, is a felony. And for those of us who speak English, not legalese in Minnesota, that carries with it not only an up to 7-year prison sentence, but also a presumptive minimum for those with no criminal history of 21 months of incarceration. So Mr. Blevins takes his case to trial. Now, curiously, he waived his right to a jury trial. Now, this is very unusual. In America, you can either have trial by jury, which theoretically your 12 of your peers, or you can have a court trial, which is a trial to a judge alone. I suspect that there might be some ugly factors going on here for Mr. Blevins. I don't know what they are. That is just complete speculation. But usually the times that you see, the few and rare times that you see defense attorneys waiving a right to a jury and instead taking it to a court trial is because their argument tends to be based around something technical where they feel like they've got the law on their side, but not the facts. These are all the facts I have. And I see weird stuff like concealed carrying machetes, but I don't see anything that's blatantly awful or something like that, Ultimately, the court winds up convicting Mr. Blevins, finding him guilty as charged, ruling that he had a duty to retreat from the confrontation, and he chose not to do so. Winds up going up to the Court of Appeals, who affirms the trial court's decision. And then because this is what we call a case of first impression, in other words, the Minnesota Supreme Court has never ruled in this before, the Minnesota Supreme Court decided to take the case. Now, I should be specific. It's not that the Minnesota Supreme Court has never dealt with a self-defense case. It's because what we're dealing with here, to split important hairs, we have got to go into a little bit of the history. And this is important, so stay with me. The history here is this. The Minnesota legislature did not pass a duty to retreat law. This is what we call a judge-created common law component. Okay, so this was something that when Minnesota updated their criminal legislation, which a lot of states did after World War II in the 50s and 60s. So it's not surprising to see that Minnesota did the same thing. The Minnesota courts added a duty to retreat to the self-defense law. So before you can exercise your right to self-defense, you first have to reasonably exhaust all of your reasonable retreat measures and opportunities. All right. That's basically what duty to retreat is. Before you can use self-defense, you've got to reasonably exhaust your retreat opportunities. But importantly, again, this was not legislature created. This is judge created. This is court created. That's what we call common law. So the issue of first impression here is not that we've got this duty to retreat in Minnesota. The issue of first impression is that the duty to retreat has, up until now, only existed for people who are actually using force. So they're actually assaulting someone. They're actually pulling out a gun and shooting. They're actually pulling out a machete and swinging and hitting someone. But that's not what Mr. Blevins was charged with. Mr. Blevins was charged with fear. So in other words, he produced a weapon that was capable of creating death or great bodily harm, and he waved it around, and that created the fear of death. That's what he was charged with. That's where we are moving the goalposts to in Minnesota. And by the way, if you think Minnesota is going to be the last state that tries to move the goalposts here, I don't know what to tell you, because look around. This is not going to be the first and only state. This is simply going to be the first state to do something like this. But that's the issue of first impression. Whether or not you have a duty to retreat even before you can produce a weapon to brandish, to end, to de-escalate, to discourage, to disengage. And keep in mind, according to multiple studies, depending on which one you want to cherry pick from, the mere production of a victim producing a weapon in self-defense when someone is attacking them, you will see somewhere between about an 88 to a 92% rate of the attackers disengaging, leaving, fleeing, you name it, which is more or less what we saw here, albeit it took a minute. So this worked out, right? Well, the courts would say no. The Minnesota Supreme Court ultimately, I'm going to be getting down to the two legal arguments here, but they ultimately say, look, you can't even brandish in self-defense. We don't want to see you even produce a weapon in self-defense, regardless of whether or not you use it. You cannot even create fear in your attackers' minds until you've exhausted all of your retreat opportunities that you can reasonably do. How crazy is that? Let me know in the comment section. Guys, very quickly, don't forget to hit that like button. And my question for you in the discussion section today in the comment field is this. Do you think other states will try to adopt these ridiculous duty to retreat laws? And if so, will they be as extreme or even more extreme than Minnesota? Let me know what you think in the comment section below. Now back to the video. But let's get to the two legal arguments. So Mr. Blevins on appeal made two legal arguments. The first one is he said, look, the duty to retreat is a judge-made law. The legislature never passed this. And basically that makes it no-go. Well, predictably, the Minnesota Supreme Court says no. They actually go back and they say, look, we first basically, by we of course, we're talking about the judicial branch, created this response to self-defense where we're adding the duty to retreat, going all the way back to when the statute was passed in 1967. And in the 50 plus years that has happened, we note that the legislature has not struck us down or passed a law indicating that we're stand your ground or that there is no duty to retreat. So because we did something and the legislature didn't change it, that means that it's okay. Now, I want to be very clear. I'm not saying that. I'm recounting what the court said in the decision that you can read in the description box attached down below. But that's effectively what the court uses to sweep away that argument of, look, you know, we did something, and even though it's not in the state legislature code, it's not in the law, it's not in the statute, because we were never reversed by the legislature, it's good enough. Now it's the law of the land. Legal argument number two, Mr. Blevins basically says that, look, the judicially created duty to retreat when reasonably possible does not apply to people who are using a threat. It only applies to people who are using force. And I'm jumping around the decision a bit here to be clear to try to make this presentation coherent. But the court's got a couple things. Number one, they say that, look, no one really argued that what you're saying wasn't force. And we think that a fear of force is basically the same thing as force, legally speaking. Right. So they first basically equivocate those two and say, you know, force and fear of force are the same. So, and as soon as you read them doing that, which they actually made in the preceding section, then you kind of know where they're going to wind up going with it. But they also say this, that look, we do not have a stand your ground law. And if people are allowed to brandish weapons instead of retreating, then we've basically created some sort of inherent right to stand your ground in Minnesota, which we're absolutely not going to be doing, because the last thing we want are good guys ending attacks statistically with a lower threat of violence and force. We want good guys being chased through the streets by armed bad guys and groups. That's apparently what they prefer, because that is going to be the consequences of this particular case. The court also went on to write, and I quote, "Requiring reasonable retreat will still permit people to reasonably defend themselves, but will also serve to end altercations and prevent escalation to the point that someone actually uses physical force and causes bodily harm or death," end quote. There it is. So they're saying that they think that this alternative to a threat of violence, namely forcing someone to retreat, will actually end in less net deaths. Now, what we're of course ignoring here is the fact that there's a morality of, if a bad guy chooses to endanger their life and my life by attacking me, I should have the right to defend myself. Not, do I have to run away? Hopefully I don't trip and fall. Hopefully I don't run into the street and get hit by a car. Not further endanger my life. Rather, I can leverage the tools that we have in society, the same tools that the bad guys are using, by the way. In other words, knives, guns, that kind of stuff. And I can leverage those same tools in order to defend my life without further endangering it in a statistical way that we know yields an extremely low chance of any kind of violence, because we know the overwhelming majority of the time, we'll call it 90%, there's not even a single shot fired where firearms are involved. All right, let's do 3 quick takeaways. Number 1, Mr. Blevins was not charged with brandishing. Many states lack any kind of brandishing law. And brandishing is just a generalized term of displaying a weapon to presumably end an altercation. That's not what he was charged with. And you have to be careful. Just because your state may not have a brandishing law, don't think for a second that a prosecutor lacks some sort of tool in their toolbox to come charge you with, as they did for Mr. Blevins. Number 2, regardless of the injustice of duty to retreat laws, it is still best to not engage if you can. And again, I don't have enough details here about Mr. Blevins' case to know whether or not how reasonable or unreasonable his escape could have been. That's not the point I'm trying to make. My point is that if you lay down with dogs, you will wake up with fleas. This is best policy, not best law, not because you have a legal duty to do so or should have a legal duty to do so, but because if you choose to engage with those bad guys, you are inviting cops, judges, and the prosecutors into your life if you decide to engage with them. Mr. Blevins was convicted after someone said, "I'm going to cut your throat," and showed him the knife. The judge, as part of that trial, ruled that he believed Mr. Blevins when he said that. He found that to be credible, but he still convicted him. Think about that. Not to mention the fact that we know that if a bad guy is within 21 feet, that is as effective, arguably more so, depending upon who you talk to, as having a firearm pulled on you. The judge still convicted him for not trying to run away. Number 3, laws change. They change with elections. They change with appointments. Elections matter. Elections matter. Vote. Gun owners, sportsmen, sportswomen, this is one of the absolute largest voting blocks in this country that undervotes by percentage. In other words, very few gun owners choose to vote for one reason or another. People, look around you. Minnesota, Illinois, New York, Massachusetts, Maryland, New Mexico, California, Hawaii, Washington State, Oregon State, on and on and on. These are the pictures of what happens when you do not go out and vote. Go out and vote. Our quote of the day comes from the one, the only, Mahatma Gandhi. Quote, "An unjust law is itself a species of violence. Arrest for its breach is more so." Wonder what made me think of that one today. I hope you're doing well. I will see you in the discussion section below. Don't forget to hit that like button, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.